religious rights and conscience rights must not be treated as second class rights, which right now they are. It's like, oh, well, they can take a step back. These other rights, even rights that we've created, even some within less than 10 years ago, take precedence over rights that have been in place since the beginning, since the foundation of America.
Some people say, well, slippery slope arguments, those are fallacies. Well, not when it comes to the law. People will push it to the limits of its logic. People will do another lawsuit, a follow-up lawsuit. There's no, so it's not really a fallacy to make a slippery slope argument when it comes to things like this, I don't think.
The best case scenario would be that the provisions that the Republicans fought very hard to have in there, the religious freedom, conscience provisions, would actually be considered, and that churches and religious entities would be able to practice according to their faith. But the worst case scenario is what we've seen happen, which is that these institutions are going to continue to be cornered in the name of equity, or and actually be sued for being discriminatory against individuals who demand these services. So that's what I see, and really, given the state of, as I mentioned, where things are going, at least in healthcare, what I see happening is that the church is going to continue to be cornered in and say, you can do whatever you want and practice and believe whatever you want on your own time, but if it infringes on my rights, on my civil liberties, then step out of that. And so that push back and forth between religious rights and the rest is going to continue. That battle is going to continue. And one thing to mention is that, we bought into the right to same-sex marriage, which is just, it shouldn't be a right? It's not. We have human rights that have already been established, and so I think that what we need to do as an institution is to show that, one, religious rights and conscience rights must not be treated as second class rights, which right now they are. It's like, oh, well, they can take a step back. These other rights, even rights that we've created, even some within less than 10 years ago, take precedence over rights that have been in place since the beginning, since the foundation of America. Okay, right? The religious freedom, the right to religious freedom, to practice according. That's what America was founded upon. And so we have to really continue to show the history of why America even exists, and to protect conscience and religious freedom, and to show that, as Phil mentioned, that really to go back as Catholics to help to teach the public about what human dignity is and what marriage means, that it's not just a contract, that marriage is something more, and that it can't just be defined however we want it to be, that there's something in the way that we were created that makes marriage between a man and a woman, whereas the other things are unions, that civil unions, you might call them, unions that have been defined by the government and don't represent true marriage.
I think that Arina just put it very well about the best and worst scenario. And what that tells you is that those Republicans who voted for this were counting on the best case scenario, and they were taking a risk that perhaps this other worst, what about the worst? They didn't count on that. I mean, they were counting on the best case scenario. So to me, they took an irresponsible risk, because they may have comforted themselves and maybe some constituents by saying, well, this law won't really have any legal bite to it, because we've put this, conscience clause thing in here. But then, of course, we could have followed it up and said, well, how is that conscience clause going to work out in the law? And they said, well, we don't know. We'll take a risk. you know, and, you know, so that's bad in itself, but it's also, of course, what both Phil and Arina were saying about the teaching aspect of the law was wrong too. So they took a risk in terms of real legal penalties, and they did wrong in terms of teaching something that they don't. If they're conservatives, they don't believe.
And that actually, I'll add a little bit too about the fact that if when Obergefell is overturned, and it will be, who knows, it might take 50 years. I hope it doesn't, the way that Roe did. Once you have something codified into federal law, it's in every nook and cranny of every law. And so another consequence of this is that this kind of language will appear in all aspects. And even when Obergefell is overturned, we will have to go back and take this out of that. And so it's a big mess. Whereas now, for example, with Roe overturned, since that wasn't the case, even though states had their own state laws regarding this, it definitely makes it more complicated when it's codified into federal law. I want to mention that.
I mean, you just look at all the remnants of segregation in the various states and laws. You see little remnants of segregation, and it took decades to get rid of them after the 1960s. And I think it's the same kind of thing. There's a phrase from Justice Cardozo about principles in the law. He says the tendency of a principle to expand itself to the limit of its logic. So there is no such thing as a slippery slope argument in the law. So there is no such thing as a slippery slope fallacy. Some people say, well, slippery slope arguments, those are fallacies. Well, not when it comes to the law. People will push it to the limits of its logic. People will do another lawsuit, a follow-up lawsuit. So it's not really a fallacy to make a slippery slope argument when it comes to things like this, I don't think.